All right, Paolo, you're on.
Okay, thank you. So this is a new study group session of LexDAO. This is going to be recorded and will post on LexDAO YouTube. So this will be about Kleros, but I will, which is basically an on-chain arbitration system. I will not enter into details because the Kleros people here will explain more. So we have various great speakers here. We have Alexandre Perez, who is DAO lead at Kleros. Then we have Ines Braganza, who is associate lawyer at Antas da Cunha, Isica and Asociados, who is a lawyer, Spanish lawyer, and a former Kleros researcher.
Sorry, I'm Portuguese, not Spanish.
Sorry, excuse me. Sorry. That's my mistake. Sorry. Then we have Facundo Trotz, who is a lawyer and policy writer at Kleros. Then we have Stephen Palley, partner at Brown Rudnick. And then Alexandre Stanescu, partner at LexDAO. So we will try to understand how Kleros works and how can be used for arbitration within the crypto space. Because of course, we all know that the crypto space has some particular rules. There is always this tension of chain on chain. So we will try to understand this stuff. So I would start with Alex. Can you please give us a very general overview of what is Kleros? Thank you.
So yes, thank you for Paolo. Thank you for the intro, and thank you for a dedicated one study group to Kleros at LexDAO. We are really happy to be here and to share more about Kleros. So yes, as a DAO lead, I don't have a huge background in law. My background is more business. But yes, for this question, I will give a bit of an overall explanation of how Kleros work and what is it. So Kleros, it's a decentralized dispute resolution protocol, I would like to say. So it is live on Ethereum mainnet and as well on Gnosis chain. And we are a crypto project that is here since 2017. So since a long time. So in order to understand Kleros, what I like to do is to do a short example of a specific case, basically, that could involve Kleros. So it's the typical Alice and Bob case. So we are part of the new economy now. So it's an economy where you can have like small tasks and small contracts between a specific person and a freelancer all across the world. So you have Alice, basically. Alice, she's a freelancer. She's from France, and you have Bob. Bob, basically, he is working online, and he wants to create a website. And in order to create this website, he wants Alice, as a freelancer, to do this website. So, like a website, it's like a small cost. It's like $2,000 or $5,000, I would say. With basically the new economy, you have this kind of very small contracts online for online tasks. What could happen with Kleros? It's like you put the money on an escrow, then you wait for the task to be done. If Alice, if she's happy with the website, everything is fine, and the payment is done. If she's not happy, basically, and she thinks like the freelancer didn't do and didn't follow the rule, then it will escalate and it will go to Kleros. And everything is on chain, basically. Everything is deal with some smart contracts. And then Kleros, as a protocol, will give back an answer, and that will enforce basically automatically as well with smart contracts. So the enforcement is done at the smart contract level. The payments will be done to Alice or Bob based on the answer from Kleros. So now I guess your question is, but what is this Kleros thing? How does it work? How can it give, like, look at the case and give back some answer? So the idea is like, basically we have a contract. You have a smart contract, and you have some parties that have agreed to use Kleros for dispute resolution. So it's like really meant to be for two parties that agree together to have a case that is judged by Kleros. Then you have a dispute that is initiated. That's what happened basically in my example. And then you have the interesting part is that you have some random jurors that are all over, basically all across the world. And there are some people that are staking the PNK token. By staking this PNK token, they have the right to work and to look at a case, basically, and to give basically an answer on if A is right, Alice is right, or Bob is right. Why are they doing that? That's the second question, like you could have, because they are financially incentivized. So that's the core idea of Kleros. The idea is to leverage things that we call shelling points. Is like some humans can coordinate within each other. And the idea is basically for the person that is staking PNK token, look at the case and do the work in order to vote with the majority of people, to vote the more coherently possible. Why? Why? It's because it's a shelling point. By doing that, this person will be financially incentivized. The interesting part is we don't have only one rule. If, for instance, the first ruling said Alice is right, and Alice, she firmly think Bob thinks the opposite, Bob can appeal, and that's the strength of Kleros, is the fact that you can have an appeal, and by having this mechanism, with an appeal, you will have more jurors, basically, that will be also financially incentivized. So you start with 3 jurors, and you can appeal multiple times until 511 jurors. So that's the principle, and we can go a bit more deeper in terms of the game theory and all the details about it. But it's a protocol that is here since 2017. We have 2,000 cases. Everything is live. Everything is on chain. All the proofs of the cases are registered on chain in the decentralized way. And yes, in terms of academics as well, we have some academic paper that I can share in the chat for those that wants to look, especially one that was published in the so it was the Stanford Law and Blockchain Policy paper. So you can have a look. It's about decentralized justice and other ones. And yeah, the interesting point as well with Kleros I want to highlight in order to conclude this introduction, it's the fact that it's at the same time a protocol that is really used for by OG crypto native projects like Uniswap. I'm sure you have all heard about Uniswap, MetaMask, 1inch, also big prediction market and big DeFi insurance. But as well, we are working on specific solution dedicated for Web2, like things around consumer claims that could be used, that could leverage Kleros, in an off-chain way. So that's a bit of the overall picture about Kleros. And yeah, thanks for that.
Yeah, thank you, Alex. So I would now give the floor to Ines. So Ines, please, as a lawyer and a Kleros former researcher, can you explain or give an understanding to us of the mechanism of incentives of Kleros for jurors? Thanks.
Yes. So my research for Kleros was not focused on incentives. We had already had researchers doing that, but I can give my take as I have been researching about Kleros since 2019. I also wrote my master thesis on decentralized justice. So I've seen the evolution of Kleros. So like Alex said, if the users are staking PNK, they have the right to look at the cases, analyze the evidence, and then vote. PNK stands for Pinakion. I don't know if I'm pronouncing it right. But just to explain, and everything that I'm saying is available at Kleros' website and also on the white paper and yellow paper if anyone wants to research more. But Pinakion is like a bronze plaque that citizens from ancient Athens used as their ID. So it was also used as a token in ancient times. So it's very interesting that it's now used also in crypto. But pretty much this token provides jurors an incentive to vote honestly, because if the jurors do not vote alongside the majority or the coherent voting, they have to pay a part of their stake of their staked PNK in the specific court where they are voting to the coherent jurors. And former researchers at Kleros have analyzed if this incentive system can actually turn this dispute resolution system biased or not. So in case anyone wants to learn a bit more about this, I would recommend a former researcher. I think actually the first researcher at Kleros. He did a guy called Luis Bergolla. He did his research on a social legal case study of decentralized justice and blockchain arbitration. This is available online for anyone that wants to further investigate more about the incentive system of Kleros and if it affects biased decisions or not. So this is just my intro.
Okay, thank you very much. So now the floor is to Facundo. Please, as a lawyer and a policy writer of Kleros, can you explain to us how in practice an arbitration with Kleros works and what is the difference from a traditional arbitration? Thank you.
Thank you. So Kleros and traditional arbitration, they both have some similarities, but they also have different approaches. So one of the main differences between traditional arbitration and Kleros is related to its main structure or governance. So traditional arbitration is mostly governed by established arbitration institutions, let's say the ICC. It involves professional arbitrators that usually have that usually are legal experts. On the other hand, Kleros relies on the centralized structure, on the centralized governance, and is governed by code, is governed by blockchain protocol. So while a traditional arbitration leverages on a pool of selected arbitrators that usually have legal expertise, this Kleros leverages a crowdsourced pool of jurors that do not necessarily have a legal expertise, but as Ines mentioned, the game theory and economic incentives can provide and grant the expertise necessary for a particular court. So this is how it works right now, and in the future, Kleros will be able to leverage soul-bound tokens also to whitelist jurors to verify that these jurors meet certain specific requirements and also be able to solve more complex disputes. The procedure is similar in some ways, in the ways that parties are able to present their arguments, to present evidence, and the jury is able to look at the evidence, to look at the arguments and make a decision. So there is a respect on the due process. However, we have to say that traditional arbitration is a more formal procedure and Kleros is a more simpler, but at the same time more flexible procedure. While, for example, another difference can be that traditional arbitration often involves hearings, but Kleros does not. On the rules that traditional arbitrators use to argue or to base their decisions, we see that arbitrators all follow formal rules of procedure made by these traditional arbitration institutions. These rules can be national laws, international treaties, but Kleros use a different type of law, if you will. So each case that is submitted to Kleros courts is linked to a dispute policy. This is how we call it. This is a dispute policy is a document that establishes rules for resolution. It has principles. It has rules that apply to the specific case. And in some way, this is kind of a help for the jurors to find this Schelling point, this focal point, and for the decision to not be just arbitrary, and also to try jurors to be to decide on a particular way. Another two big differences are costs and times. So traditional arbitration can be expensive for some parties that want to solve a dispute of low cost, as Alex mentioned. It may require also physical presence. Traditional arbitration also may last months, even years, while Kleros lasts only days, depending on the particular case, right? But and also it may cost a couple of dozens or a couple of dollars, less than $100, depending, of course, of the court and the specific case. Also, there's another difference that is related to transparency. If you want more confidentiality, probably traditional arbitration is still a better solution than Kleros, because Kleros leverages blockchain technology, and transparency is one of the main pillars of this dispute resolution system. So to close this summary of differences and similarities, I will say that both have their own advantages and disadvantages. Kleros is more well-suited for small claim disputes, for on-chain disputes, while traditional arbitration remains essential for more complex and disputes that require more expertise in the jury.
Okay, thank you very much. So now I will pass to Steven, correct? I'm sorry if my pronunciation is not correct. You are a US dispute lawyer who handles trials, arbitration, litigation in the crypto space. So please, can you give us your opinion about Kleros as a solution for arbitration and dispute resolution in the crypto space, or what do you think about Kleros? Thank you.
So before I give my feedback on Kleros, I want to talk about the question that it asks and attempts to answer, because to me, that's really important.
Yeah, sure, please. Of course, it's a broad discussion about Kleros.
Yeah, so I want to focus on that first. Litigation is a really inefficient way to resolve money disputes. I've known this, I've been practicing for 25 years. I knew it the first time that I settled a case. We ended up, after a lot of fighting, settling a small case. This was like $5,000 case for a number that the people involved would have paid in the beginning, but they needed to go through a process to get there. So a lot of what we do doesn't make sense. Also, I read through, I think I read everything on the Kleros website. And I agree that litigation, arbitration, and mediation don't work well, particularly in the United States, where everything is very expensive, don't work well for small disputes. Now, we do have in the US and in other places in the world, we do have small claims courts. So if I have a $300 dispute, I can go to a small claims court, a judge who has limited jurisdiction, and typically under a certain threshold amount, will resolve that dispute. So I think the question of solving, and there's social justice issue here, there's an economic issue here. A lot of what we do, even if you're dealing with hundreds of thousands or millions or in the low seven figures, I have this conversation all the time with clients. What you want to do, it doesn't make sense to litigate. It will be good for 3 reasons. This is a line I use, and I give them the name of my children, right? Because I'm going to make money, you're going to lose. Now, the more complicated question is, so I think that I take the, there is an earnestness I see in the materials here that I take seriously, and an approach to the problem set that I think has to be taken seriously as well. And I recognize that others like eBay, for example, as an example, or Modria, pioneered the concept of online dispute resolution. Here's where I question, and my questioning of the approach is not a question of the good intentions, or nor is it a suggestion that anyone should stop. I fundamentally disagree that a staking model where voting with the majority is used to incentivize correct results. I don't think that it works, except in the most deterministic, binary situations where you have some sort of oracle, trusted data source. I think in those situations, or you think of the sort of economics of a delegated proof of stake system, those are in computational systems where you're dealing with routing or you're in a closed system, voting with the majority and being incentivized to vote correctly. That I get that. Here, even in the website context, that is not, to be clear, and again, I want to challenge the language that's used here, that is not an on-chain dispute. It's a dispute where money has been escrowed on-chain, which I think is one of the most useful and interesting ways to use blockchain. Money's been escrowed, but the dispute itself is resolved off-chain. I'm not even sure what an on-chain dispute is. In fact, I would submit that there is no such thing as an on-chain dispute. What you have are programmatic resolutions based on inputs. So the blockchain isn't resolving anything. I think too, this is my own personal bias, and it's based on stuff that I tried to build 10 or 15 years ago. I think that the answer to solving for disputes using blockchain is to build better agreements, because once you have a broken agreement, I just don't see anything about game theory that solves for human disagreements. I would even some of the I don't know. I can stop when you tell me to stop, but I disagree with some of the other premises. Another premise too.
No, please don't stop. I will only give the word to Alex, Ines, Facundo after you. If Alex, that's fine for you. But please finish your
argument. I read through this excellent compendium, the dispute resolution, and I enjoyed it immensely. And this is a passion of mine, figuring out ways to resolve disputes efficiently. But I think that behavioral psychology and behavioral science is more important in understanding how to resolve human disputes than game theory. I don't think that game theory, people aren't rational when people are rational, but they're not rational in a game theoretic way when it comes to disputes that involve emotion and psychology. And the research is shot through with examples of this. So I would also dispute the premise that there's a comment here that the exponential decrease in computation and communication costs have enabled adjudication to be done by crowds on a massive and global scale. That's not true. And there are a couple of things about it that are not true. First, computational power, the inexpensive nature of computational power, has actually made disputes harder because it's increased the amount of documents and discovery that we need to use. And there's nothing about computation that changes human psychology. I also don't know that I agree that transparency is a key feature of a justice system. I know that that's insane, right? It's a crazy thing to say, but I'm not sure that how the cake is made. Maybe you want to know what the recipe is, but I think the key to a justice system that works is people believing in the outcome. So I don't know. Those are some of my initial feedback. I get the concept too that, well, you know, you might like the proof of the staking might not work on a one-off, but over time, people will be incentivized to vote correctly. That presupposes that everything is that there's a that people operate that way. And there's a reference in part of this book to 12 Angry Men. I think that that's apt and important. The concept of a system that is focused on the belief, like if we had systems of truth that were based on what the majority believe, we would still believe that the sun revolves around the earth, not vice versa. So like interesting use of technology. The premises are wrong, I think. What I would do is I would build dispute mechanisms. I would automate dispute decisions before there were disputes. But one last thing, if I can too.
Please.
There's a section in here that one of the innovations that suggested it is we don't let people read the entire contract. We only extract relevant clauses or provisions. It's not really how contract interpretation works at a fundamental level. These things all have to, I've been doing this for 25 years. When you have a contract dispute, you have to read the entire contract. So I don't know, maybe it makes sense for highly technical disputes where there's some element of automation. Maybe if we think of it as I think if you call yourself a court and you call these people jurors, you take on a certain kind of gravitas, you add something to what's being presented that I'm not sure it actually is. I would rethink the entire concept of disputes and rebuild around that, as opposed to rebuilding around a system that will functionally and fundamentally always be built around human discretion. So that's my feedback, and I hope the Kleros people take it as friendly feedback, not a shot across the bow. I admire the breadth of what you're attempting here, and there's something there. That's basically, I just had lunch with two of my partners, lawyers here, disputes people, and I'm trying to figure out where it goes. Like, what's the thread? I think there's a lot of noise here, but I feel like there's a thread that makes sense, and I'm just not sure that I've extracted it. I'll shut up.
Yeah, thank you. Of course, this LexDAO Study Group we try to create independent discussions. So, but I would say to give the word to Alex, Ines, or Facundo, one of you that wants maybe to answer to Stephen. So Alex, please, wait 1 second. So I don't know if some of you wants to answer to.
Oh, can I add one last thing before the answer? This might help you. I don't think that the truth is found at a Schelling point. It was really interesting that you used that, but I think the fact that people met at a certain point at Grand Central doesn't mean that it was the best place to meet. It was a place that by consensus and convention people met, but there's no truth there. I think that is the concept error that happens when you try to apply, I don't know, game theory to complex human interaction. Now I'll shut up.
Please, one of you, Alex, Ines, Facundo, want to answer to? Yeah, please.
I can do maybe a quick and short first answer.
Yeah. Take your time, please.
Yes, I think on your last point, yes, definitely, it's we are touching like a more philosophical, complex concept now. What is the truth? Is it a Schelling point, or is it something, coming from a court, or is it something moral? The goal of Kleros is not to go on this philosophical spectrum. The goal of Kleros is not to deal with scientific truth. You mentioned, for instance, Copernicus and the sun going around the earth, or like questions that are too subjective. So that's definitely not the goal of Kleros. And maybe also to answer your last point, you said that there were a lot of noise and a lot of interesting stuff, but you were struggling to see maybe a specific use case. Maybe I want to share something specific that we are working on that might interest you. So we are working right now with a company called Lemon. So Lemon, basically, it's like Coinbase, but for Latin America. So it's a huge company. And basically, this huge company like Coinbase, they have customer claims. So they have issue with their customer because, you know, it can happen like the cryptocurrency was not received on time, or it was sent to the wrong address. These things happen, and you have all basically this system and all these people in customer service dealing with these specific claims. So that's something very concrete, basically, that can be measured, and that has a cost, basically, for this company. Why it has a cost is because if the customer is not happy, most of the time, he just leave the exchange and never go back. So that's a cost for them, and it costs them money to do the claim, to deal with the claim, and also because they will not earn fees from the customer. So what we are experiencing right now with them, and it's a program, and we had, I don't have in mind the exact number of cases, but it has done a lot of time. It's like there are two levels. First, if a customer has a claims, then it will be done, it will be looked at by the Lemon company internally. That's the first stage. The second stage is if the customer disagree, he can ask for Kleros to have a look at this case. So that's something very concrete. And by asking Kleros, he still, of course, has the rule to go as well to small customer claims dispute court. And you mentioned this specific kind of court in your talk. So they still have this right. So basically, for the customer, it's like a win-win solution. So they go for Kleros, and basically, what happened? What happened is you have real human that look at the case and that are a neutral third party, and they will give an answer. They will give maybe the exchange Lemon is right, or maybe the customer is right. And it has happened in some cases that they go against the exchange. In this case, the exchange, Lemon, agreed basically to respect Kleros ruling. Why is it interesting for Lemon? First, because it's way cheaper for them. They can pay a little bit, basically, Kleros system for this off-chain resolution in this case. But what happened is the customer received the feedback of a juror. That is a real human. That is somebody external as a neutral third party. And by doing that, the customer feels heard. And that's why where it's interesting for the exchange. It's because even if sometimes Kleros rules against the customer still stick with the exchange because he was feeling heard of by a real human. You know what I mean?
I know exactly what you mean, and that's exactly right. I don't disagree with you, but I'm not sure what that has to do with on-chain arbitration. You're describing something that that makes sense to me, and that's one of the reasons why I tried to build a dispute resolution platform that was based just on money. And one of the, where you basically have a kind of an auction process. What I heard was people need to be heard. There's psychology to it. So I guess the question is, that's cool. I get that. And it could be that's a great model for Kleros, and I hope it's wildly successful for you. But I think you just proved that you can't, that crypto economics and game theory don't solve what dispute resolution does for a lot of people.
I think as you mentioned, it's bringing basically these human feelings, and you mentioned it in your speech. And I think the interesting point is you also mentioned eBay many times, and yeah, I guess this is a huge company. They have thousands of claims, and the former director of online dispute resolution for eBay and PayPal. His name is Colin Rule. He's also a professor in many universities. He's a very strong supporter of Kleros. He has deeply looked into it. So in his way, for this kind of specific use case, he thinks it really makes sense. So that's really interesting to see somebody that was deeply in this business, seeing something there, basically, in terms of efficiency for companies.
Okay, so I will give the word to Alex. Alex, please, you can, as a European Union lawyer and litigator, dispute lawyer, arbitration lawyer, please give us your opinion. And of course, feel free to comment on just this ping pong between Alexandre and Steven. So please.
Thank you very much, Paolo. Everybody, I'm very happy to be here with you. It's indeed fascinating. I also studied Kleros some time ago, and as much as possible, I try to include it on specific, dispute resolution mechanisms in some of the blockchain transactions that crossed my desk as a lawyer. I have 2 points to make. First is a sort of a response to Stephen, who really thought very thorough through what is Kleros, especially in the what is an on-chain dispute concept. So it's true when you think of it, it can look like a sort of an escrow arrangement, but for me the core of what is an on-chain dispute relies in the specific nature of the self-enforcing contracts. So it's a matter of maybe less on law, but more on practicability. So as long as you can self-enforce the contract, you can be in the realm of on-chain disputes. Maybe dispute is not the right word, but I mean, or resolution is not the right word, yeah? Because it is an on-chain dispute, and we've seen it with Kleros, and Kleros had some cases, and we've seen it also in other DAOs or other blockchain ecosystems. People, they do have disputes, and when we are talking about on-chain disputes, as long as I'm concerned, it's a dispute that can be solved without the intermediary, so which can be self-enforced. So as long as the services or the goods are delivered on chain, and as long as the transactions can be executed on chain, we will be in the realm of on-chain disputes. Now, as we go with one of these nexus outside of the blockchain, we are in the realm of off-chain dispute resolution, where a lot of bizarre animals from the legal space start to appear. Applicable law, enforcing of the arbitration agreement, enforcing of the award. So we really get into what lawyers will deal and will say that Kleros might not be the right solution, as long as we have a sort of an off-chain element. On the Mexican, and here are also the problems maybe with the Kleros system, but let me start by saying that Kleros, it's a good, in my opinion, it's a good tool, it's a good mechanism to solve these specific disputes. Like Alex said, it's a sort of a delivery of an NFT, or a contract for services for delivery of digital goods that can be fully put on chain. But for other things, it starts to get complicated by using Kleros. You might know the Mexican, and we can even discuss afterwards about the Mexican court who enforced an arbitral award which was stemming from a Kleros decision. But again, that was not purely an arbitral award. So basically, the arbitrator was instructed, so there was an arbitral agreement, and the arbitrator was instructed to follow or to ask the Kleros court for a decision, and then it put that decision into his award. But then, of course, a lot of questions might pop up. Is like, are you an arbitrator who needs to use the discretion and to arbitrate, or you're simply a secretary of a system which by itself provides the rule and you just embed it in an arbitral award? And my last point for now would be on the fact that maybe we're talking about justice, but I think that we need to differentiate between justice and other services. And Alex again provided an interesting example of Lemon, and Kleros has other examples as well. Probably we need to think of Kleros as a system for on-chain dispute resolution, but also for discretion as a service, I would call it. It's a sort of you'd need a sort of the crowd, the crowd intelligence to be used as a sort of a discretionary power when you would need that. And then again, for example, centralized platforms like LinkedIn or Facebook, they use all sorts of bots, or also or even eBay. They use this sort of discretion as a service when they need to, if a post it's against their policies on non-discrimination, Facebook if it's a fake news or not, Lemon if crypto exchange operations are flawed or not. So for the sake of efficiency, I think that more and more systems will appear. They will look like a justice system or dispute resolution system, but they will not be in themselves philosophically and also practically justice as a service. They will be discretion as a service, and we need to make the distinction. And to go into the atomic bomb, now we are using crowd justice systems, but then who says that it's better to use a crowd intelligence justice system rather than an AI discretion or justice systems? And probably that's for for the end of the discussion. But I do believe, because the practicability, it's practical and it has been used. So they say that the need create the function, and there was a need in the on-chain world. It might be a very small niche in the ADR system, but it's there, and the solution needs to be found for this type of disputes which are on-chain. Thank you.
Steven, would you like to answer maybe to Alex? Please. Feel free to elaborate.
No, it's okay. I again, it sounds interesting, proof of discretion, but I don't know what it means. And I will tell you that my experience, particularly with technical disputes, is that you really don't want, I don't know. I had a jury trial involving very complicated insurance and 100 years of environmental liability. The jury sat for a month and rendered provided an outcome. I'm not sure that the fact that we had lay jurors, actually did very much. So the notion of crowdsourcing solutions to disputes, I just don't think there's anything about crypto or blockchain that does that. The thing that resonated most with me, frankly, was when, do you go by Alex or Alexandre? I'll just call you
Alexandru, but both work, Steven.
Yeah.
Thanks.
Well, so both of you, yeah. I guess in order to be associated with Kleros, your name has to be Alex. So I'll never be able to use you. So the thing that made sense to me is really kind of a Web 2 concept of, so we help make people feel heard, and there's something about using crypto that allows you to automate a piece of the resolution because there's an escrow. I also there's another interesting thing that you did, which I'm kind of curious about, the notion that you can appeal as many times as you want. You just have to pay more each time. I don't think I've ever seen that before. And that's interesting. You can it's not even really an appeal, right? You're just retrying the case. That's a curious. I want to think more about that. I just don't think I've ever seen that concept used before. But I come back to not really understanding what you mean by proof of discretion in the same way that maybe it's because of my education and background. I see mathematical formulas applied to human disputes, and my eyes kind of glaze over. There's nothing about it that speaks to me. So, what do you mean by proof of discretion, Alex? Can you tell me more about that concept?
Yeah, look, it has not been, so it's a sort of a personal opinion. So it's a sort of a downgrade from the idea of justice, and we go just in the idea of discretion. There might be some disputes where the parties would agree that a sort of a formal mechanism for disputes is not needed. Why? Because it's more expensive. The dispute might be very small, and because the parties chose to do that.
Why not
So
just flip a coin then?
it could be a mechanism as well.
Actually, I'm not kidding. I reached the conclusion when I was trying to design an online dispute resolution system that you might just actually want to have games where people could compete, and that might give people as much I don't know, feeling of resolution as anything else. You have an
But then-
online game, and whoever wins the dispute, and we acknowledge that it's going to be as fair as getting two random people to solve it for you.
The big difference, Stephen, is that when you flip the coin, there's no slight appearance of fairness.
Really? Well, so that's interesting. So then when we strip it back, what we recognize again is what we heard from Alexandre. People want to be heard. The reason why the coin flip doesn't work as a dispute resolution process is because people want to believe that it's just. They want to believe that there's something fair about it. They want to believe that the resolution follows from the process. A coin flip is arbitrary. But I would submit to you that honestly, like in the wild, a lot of what happens, and I've spent time in small claims court, landlord tenant, really small dollar stuff. I've handled really big cases. A lot of times the resolution depends on how good the lawyer is, who the other side is, and who the judge is, whether or not you have money to survive. So maybe the answer is it's an online escrow and a coin toss. But again, I think what's interesting is right. What it comes back to is sometimes people just want to be heard. Like there are cases that are very hard to turn into like a pure binary. Family law dispute, divorce, right? You find cases like that. People are really angry. It's not about money. So principal cases or cases that are heavily emotional, you can't do that way. But I don't know, like honestly, if there were a system where you could, it was just pure betting, it almost like it took litigation and turned it into roulette. There are a lot of cases where I would tell clients to do that. I would tell them they would have from a pure, when we get to like game theoretic, so let's talk about this too. And let's just stipulate that I'm only talking about money cases. If you're talking about game theoretic resolution and you're talking about economics, you're talking about the best financial case. So let's say you have a 65% chance of winning $1 million award in 3 years. The net, that means, and it's going to cost you $200,000 to get there. That means that the net present value of that $2 million is going to be what? Let's call it. It's going to be $1 million. 70% of $1 million is 700,000. $200,000 cost. What that means is that what you should take today is $500,000, right? Like we can reduce all of that into pure, absolutely pure math, which means that that you can take most of the process out of it if you can convince people that it's just about a number at the end of the day. So I think that the sort of the tension here in the system that you're describing is people want to be heard. If we're talking purely about game theory and economics means what's the most you can get and what's that worth today. And I deal with that, those of you who are disputes lawyers, I deal with this crap all the time. Why should I take $200,000, Steve? It's like, well, you're going to pay me 100,000. The most you can get is 400,000 in 2 years. And you've got to like discount, you've got to discount it for, inflation. It's that. I think your system could actually capture that, but I don't think you do.
Someone wants to answer? Replies?
I don't even know if there was a question. I'm just blathering on.
If I may,
Please, Alex. Please.
It's just for the constructive debate with Stephen. I don't think that, and again, I was a Kleros fellow time ago, so in a way I'm biased. But I don't think that the promise of Kleros is that it's a sort of a panacea for everything online, for any dispute or any type of. So that's why I was discussing about discretion as a service. There are some situations where users of Web3 solutions or ecosystems would prefer such a system like Kleros rather than relying on a traditional, a classical dispute resolution system, be it a judge or an arbitration, mechanism. So I think that was the promise, and I think that they are very much into, because as in arbitration, whatever the parties choose, it's good as long as they are happy with their choosing. As long as, of course, that there are procedural fairness involved in other aspects of procedure. But Stephen, while I do understand the pain points that you're presenting, for a DAO, for example, would you consider that there could be a better alternative than such a system? And if so, which one? And sorry, apologies, Paolo, not to take the sort of a moderator role.
No, please, no problem.
On this one, yeah.
I mean, I have some DAO disputes, and they're a friggin' mess. And the fact that you've got, what's the voting system called? You know what I'm talking about. Snapshot, the ability to take
one token, one vote on Snapshot, yeah.
Yeah, the fact that you've got Snapshot and you've got Discord, it doesn't make anything more complicated. It makes it more complicated. So adding this into a situation where you've already got a DAO, and whatever that is it loosely coordinated group of people? Is it an unincorporated association? Is it a general partnership? Then adding in a staking component. I think you've just added most DAO disputes that I've seen. And remember, I typically only see this stuff when there's a problem. It's all people fighting about money and power. It just happens that they don't have a coherent governance framework because they decided they would reinvent 3,000 years of legal technology and put it on the internet. So I don't see how this solves for that, unless you're building it in. The thing, what would be interesting is if you had like almost a dynamic arbitration agreement. You have basically a wet dry contract, right? You've got where you have a dynamic arbitration where the performance part of the contract, the dynamic part, is on chain, and it can act based on information that it receives. Like, and if you basically go back to the original Nick Szabo concept of the smart contract, if you can build that, then you don't need to have arbitration because problems solve themselves. I don't know that I've described that in an incredibly useful way, but you can imagine DAOs that build hooks into a sort of self-executing dispute resolution protocol that's basically part of the governance structure. If you do that, you don't actually need people, because the protocol fixes itself.
Unless it needs an oracle with some input, right?
Sure, exactly. I'm curious, and again, like I know, Paolo, you're the moderator, but let me
Please,
ask,
please.
like, I read this. I read,
Feel free to ask questions. No
I want to ask if somebody can explain to me this line. The PNK token is a critical part of the crypto economic mechanism because it prevents Sybil attacks and provides incentives for Kleros to provide true verdicts. I don't know what that means.
Anyone?
What, anybody?
So yeah,
Alex,
I can
yeah.
try to
Why
explain
not
that.
just like, why not just
I
use
think-
Bitcoin?
I think it's related to your point about appeal. Basically, I think that's the big strength of Kleros. It's as I mentioned, basically you can have several appeals. So basically, it starts with 3 jurors. The jurors basically they don't know if they are in the final round or if they are in the very last round. So they have staked their PNK. If they vote coherently, and in this in your example it's mentioned true, but it's all about coherency, it's all about voting with the majority. If they vote coherently, they will be basically rewarded by the PNK / by the other party. But if they don't vote coherently, they will get slashed. And they don't know if they are in the final round or if they are in the first round. By doing that, it's a good way to have basically the wisdom of the crowd from a small sample, basically, of jurors. Why basically the token is securing the system is because you have already a lot of jurors that are staked in many courts. So basically, in order to try to Sybil attack the system, what you will have to do, you will have to buy a lot of PNK and to stake this PNK in a lot of courts. This will cost you a huge amount of money. It will be very expensive for you in order to basically try to break the system. And by trying to break the system, you're not sure you're going to try to break the system. Secondly, everybody will see you because we are on chain. And that's also one of the strengths of transparency. We do believe, basically, that's why this system is relying on game theory as well. It's also because everybody can see it. So what you will do is you will spend like millions and millions just to potentially break the system. And what can happen is because we are in crypto, anybody will be able to fork, basically. And anybody will know that this version is not trustable. And you will have a fork. And I think that's basically why you need the token to secure the system, the PNK token to secure this system, and why you cannot rely on other solution and why it is strength. And maybe to go back as well on one of your points related to DAO and why basically some people would want something automated like Kleros. There were some famous cases in Kleros, and yes, we had these cases, for instance, with prediction market. And you know, prediction markets are this thing we can find on blockchain, on crypto. Recently, there was this case about the fact that one of the big questions was, will Joe Biden win the 2020 United presidential elections? And the end date, basically, of this prediction market was basically matching the end date of the election. But if you remember the 2020 election, it was a bit of a mess because it was very close and many people were asking to revote, basically, the Trump side. What happened is these guys go on Kleros. And that's where basically we think and we do believe like everything is on chain and it's deterministic. And there was this huge amount. At the end, it was almost 2.5 million that was basically adjudicated by Kleros jurors. And of course, the Trump side had a lot of money involved. So basically, they appeal a lot of time. And by appealing a lot of time, they almost reached I think they reached the full number of jurors that rule the more coherent way. And that's also what we want to highlight is we have more than 2,000 cases, and you can check everything is online. And yeah, if you think something is definitely not making sense or it's completely arbitrary, let us know. But it has a proven track record basically of coherency, and it's completely different than just flipping a coin.
Stephen, please. Of course, this is just a debate, an exchange of opinions. So please feel free to answer. Stephen, would you like?
Oh, I'm sorry. Hold on a second. One second. Where am I? I still am not persuaded that rewarding people for voting with the majority will do anything. I think it's net zero whether or not it will lead people to correct or incorrect results. So again, I'm looking at this book that was put together, and I'm quoting, following the Schelling point principle, Kleros assumes that jurors who voted incoherently with the rest were not properly qualified. They self-selected into a wrong subcourt, that they did not conduct a proper analysis. They voted quickly just to collect the arbitration fee, that their goal was not discovering the truth. They were bribed. I mean, that's a wild, wild statement. And there is, I mean, it is what I'd call, if I were writing a brief, bald ipsa dixit. It's a statement that is supported by itself. You're saying that it could be that the person who didn't vote with the majority was the only person who knew the right answer. But because of the way this is structured, they're going to end up getting a negative reputation. I don't think that accuracy, I don't think that accuracy in adjudication can safely be tied to economic stake. In fact, it might actually be the opposite. Now, interestingly, I mean, jurors are actually paid in the United States, not paid very much. And this is, it's sort of conventional wisdom too, that if a case ends before lunch, you almost never get a jury verdict until after lunch, because fuck it, you're gonna stick around and let lunch be brought in. But I don't know. I'm kind of stuck on that. I think at a fundamental level, I have a hard time accepting that coherence, qualification, or honesty are tied to voting with the majority. And the majority is wrong so often.
Okay. Anyone wants to elaborate on that? Alexandru, maybe?
I have a question for Stephen.
Yeah, please.
So that again, it's more on policy. But among the few remaining systems with jurors is the US system, right? Yeah. And there you either have unanimity or you have, depending on the state law, 9 out of 12, like a general rule.
Depends, yeah.
But then again, jurors are used in the US. What's the big difference? The fact that there is a judge who oversees the procedural fairness of the trial, or do you think it's more?
Well, so there's when you pick a jury in the United States, you go through something called voir dire, or if you're in the Midwest, it's called voir dire. So if any of you speak French, you should be appalled. But you get to ask questions of the jury, figure out what their biases are. Sometimes the judge will do it. It depends on the court. But there will be jury questionnaires. There's an entire industry that is built around figuring out who the optimal jurors are. And one of the common jury instructions, one of the things that you get a juror to agree, is that no matter what they think, they will follow the instructions that the judge provides. I actually have a decent amount of faith in juries to get it right. And the same thing with judges. Now, judges, interestingly, some judges in the United States are elected. not appointed. And if you're elected, it means you need to campaign, which means that they get paid money. And I'm not going to name the courts, but I've been in courts before where the lawyers who were trying the case had actually helped pay to put the judge on the bench. To me, that's actually maybe more of a problem even than juror bias. It's potentially judge bias. It's kind of like what Winston Churchill said about democracy. It may be the worst possible system for resolving disputes, but I think it's the best that we have, which comes back to, I think the way to make dispute resolution fair is mechanism design in, it's rethinking rather than trying to rebuild a process that doesn't work very well, actually building games, actually building software that either cuts off the ability for there to be disputes in the first instance or resolves things in novel ways. Honestly, like the coin flip, I know it sounds crazy, but I do have this idea, and I've had an intuition for a long time that allowing people to resolve disputes in using online gaming, it could actually work and could leave people feeling just as good or bad as a solemn process. So I think, I'm not sure that entirely answered your question, but civil juries work.
Yeah, I mean, the idea that the jury would not fit would not provide the solution to disputes. I wanted, to
It's
get what it's more in, in your
it's
jury
really it's
system.
problematic. Like if I mentioned this case I had, it's a very complicated case. It involved 100 years of insurance and 100 years of pollution involving PCBs at a rail yard. And, we had, I think we had 12, was it 9 jurors or 12 jurors? I can't remember. We had 12 jurors, lay people, having to solve this really, really complicated result. We won. So obviously they were a great jury. But in retrospect, when the number came back, we were like, that's really interesting. We have no idea how they got to that number. And the judge wouldn't let us talk to them because the other side didn't agree. So there can be somewhat, even though I think that the jury system is set up in the United States to be fair, it doesn't always make a lot of sense. And, to get back to like one of your threshold issues, we have a dispute problem in the United States that the court system doesn't solve. And $500 might not be a lot to the people on this call. There are a lot of people for whom it's a ton of money and it matters. And we don't really have a system that solves for that. So I would say, like, whatever I think about your premises, congratulations for trying to build something that fixes that. I think there's something to it. I just don't know that I agree that a token or wisdom of the crowds is a necessary component of that. So
yeah, maybe to put also a bit of context, we don't want to replace like all arbitration system.
I get it. Yeah,
it. We are really at Kleros, the focus, it's really about like cases that are not too subjective. Like, of course, cases that are really subjective, where you need a specific, or where you need, basically it doesn't fit in Kleros scope. So we have, for instance, token curated registry, like is this token a scam or not, for instance. That's part of subjective, but there are clearly some tokens that are clearly scams. And as well, I will put the link, it's as well on the famous Kleros case. There were this coin, it was called Bayer coin. It was like in China, it becomes huge. And basically, yeah, everything was fake. They had fake CEO, everything was fake on LinkedIn. And basically by going through the Kleros process, with this question, is this token a scam? It was part of one of our product. Kleros juror find by calling directly the university of the pretended scammer, that those guys were just fakes. And it was like, as I said, a subjective case, but not too subjective. Of course, if you go in the realm of something that is too much subjectivity, maybe tossing a coin, as you said, could work. And I think it's a very interesting experiment, like a jury against an AI, against a coin. Like, which one is going to be the best if something is very subjective. But if something is not too subjective, like for instance, the Biden 2020 case I mentioned, I don't know in which world the Trump supporters were living, but for them, Trump won. But I mean, we all can agree that Kleros has proven his sanity by saying that it was not the case, So basically, it's about those cases that are not like completely subjective that Kleros is useful. I think we need to keep that in mind.
Yeah, it's going to be interesting to see what data computational power does, because if you can give somebody and this is beyond what you're doing, but if you could theoretically give somebody data that says, we've looked at your case, and in 87% of cases like this, the result is blah, blah, blah. Provide some numbers. I think a lot of cases, like you can settle today for blah. A massive number of disputes would be settled. And one of the reasons that, and if you can do that, and this gets back to maybe sort of the utility of blockchain or computers, the reason why people won't settle cases sometimes is because they hate each other. They don't trust each other. This is actually the thing that got me to discover crypto in the beginning is the notion of trustlessness. So if you can take the need to trust an intermediary, a lawyer or mediator, out of it, and you can bring this back to what I call, like, if it's really a numbers dispute, if you just see the numbers and you have, and I hate the word oracle, because an oracle is actually a thing shrouded in mystery, right? But if you can take something that's verifiable and trusted, that has access to really good data, and it could spit out parameters, you could actually solve most disputes without even needing PNK coin or arbitration. To me, that's where the answer lies. It's not in recreating a basically flawed and fucked up system. It's thinking about it completely differently.
AI, artificial intelligence.
Yeah.
Yes, but yeah, I think it's artificial intelligence. It's like very interesting, and it's gonna be definitely part of the mix, I think, of online dispute resolution system. I think it's not gonna be one solution fits all. I think it will be definitely based on the level of subjectivity, based on the case, based on a lot of parameters. I think for many disputes, AI will make sense, and yes, I think for a lot of other disputes, as I mentioned, when you have a dispute, it's emotional, and I guess we agree on that. People want to be heard, and you prefer to know that another fellow human has a look at your case rather than just an AI. But yeah, that's interesting debate.
Wasn't one of the someone just sent me a note about this, not to be controversial, but one of the biggest insurance claims to date was a 742 ETH loss caused by the UST DPEG, and that was referred to Kleros. There's a long thread by an internet sleuth who says that the claim was rejected a bunch of times, despite it having clear merit. I haven't dug into that, but is there any truth to that suggestion? Because that's a lot of the 742 ETH loss. That's a lot of money, right? So we're not talking about a couple $100.
Yes, as I mentioned, you can check. There are famous cases about Kleros handling millions of dollars. So yes, there are some cases that are more controversial than others. Maybe the one you're mentioning involved Avraham Eisenberg. You might have heard about this guy.
Mm-hmm. Yeah, sure.
So yes, he tried to attack Kleros basically, and I think it's the case you are referring of. And yeah. It was a very, very complicated case. There are like tens of like basically proofs and debate, and I can share the case basically with all the debate and a lot of rounds and a lot of documents are produced by people that are also the way they write the documents and the evidence. You can see there might be lawyers. It was a super interesting case. At the end of the day, people can have their own opinion on that, but yes, it was an attack from Avraham Eisenberg against Kleros, and he lost this time. So yeah, it's a very complex case, and yeah, feel free to dig into it. I will put the number of the case. Everything is online. Everything is transparent. Everybody can see. Everybody can have a look. But yes, he wanted to do a precedent basically with this case in order to extract value from Kleros, as he did with Mango Market and Aave as well, and Treasury DAO. Yeah.
Okay. I don't know, Alex, maybe you have something to add, or some other, Ines, Facundo.
I can just add my two
Please.
cents. I was so interested
please,
in
Ines.
just listening to the conversation. I wasn't really speaking. But I think we must distinguish between two things. One is what I usually call on-chain arbitration, and that would be like the smart contract itself solving a dispute without it ever appearing, pretty much. So I don't think this is what Kleros is doing. Is not what Kleros wants to do, and that would be what I call the real on-chain arbitration. What I do think that Kleros adds to this whole digital economy ecosystem is really the power of community, and like what Alex talked about, proof of discretion, which I had never heard about, but it's very interesting. I do think that it can rally people's opinions, and then that community or that community's power, so the opinion that those people have can be integrated into several platforms, like the Lemon exchange that Alex mentioned. Also in my research, I focused on how Kleros, and not only Kleros as a dispute solver, but Kleros tools, what I would call, so Kleros integrations or Kleros applications, how they could be integrated into platforms that were tokenizing RWAs, so real world assets. So I do see Kleros as this umbrella of solutions that can be integrated into already existing platforms. And for the crypto space, I do think that having this power of community and having the community be heard is extremely important. So I wouldn't really call Kleros as on-chain arbitration. I know probably in the papers it's how it is. For me, on-chain arbitration is something else. So I think we should always, when talking about Kleros or when discussing about Kleros, we should definitely distinguish between these two things.
Any answer? Any other comment?
If I may,
Please, Alex.
my last 2 cents on these very interesting discussions we've had. I think we are now at the moment in time where, as Stephen was saying, we need to think of how to design efficient alternative dispute resolution systems. Kleros is one of those. It can be a system for a specific niche of situations where the mechanism of Kleros could give very good results. Even in Europe now, we are struggling with, especially for consumers, of designing. We have the ADR the directive on how to improve the systems for consumers, because what's going to happen is more we live in the on-chain, more we do transactions online, more we will need this type of systems that can easily and efficiently solve disputes or any sort of discontents for consumers and parties. So in this respect, I think that Kleros can be a starting point for on-chain disputes where the parties can, on commercial issues, on money-related issues, could choose this as a very efficient system that could solve their, their pain in terms of, and they could trust the system. And as long as it's their decision to trust the system, which is very clearly, outlined in the Kleros mechanism, it should work. Time will tell, but I'm still a believer in Kleros in this respect.
Okay, Stephen, would you like to answer? Yes, no?
Yeah, I don't have anything more to add on that point.
Okay, great. Simply, do we have a question, right? Am I wrong?
We have two questions.
Yeah, please.
I see right now.
Yeah, please.
So, Nicholas, would you like to jump in and? Oh, actually, I may need to change the rights of the meeting, but give me 1 second, and I will allow you to jump in and ask your question. Let's see. Go ahead, Nicholas.
Yeah, thanks. I had asked these at kind of points in the talk, so I'll try and go back. But maybe questions for Stephen. You were talking a lot about human discretion. Like, to me, the way that I had always looked at token voting and staking was that it's almost just like a spam filter. Like, none of this is actually going to be secure. Like, we ultimately are going to fall back upon some social layer or context of truth that's going to be abstracted away from Kleros. Kleros in general it's basically just this idea of, in what way they were talking about discretion, is it's not a dispute resolution mechanism in the sense that like your traditional parties of like, we're arguing over $1 million, we might as well just settle for 200 because we're not going to make it. Like, that works for a traditional dispute, but in these ones, you're just going to keep redoing it. Like, it's like repeated game theory. So like, it's more about like, even if both parties lose complete money, like everything, and Kleros is honest about the answer, that's more of the goal, because there's an underlying system that's relying on this. So like, like the Palley market case, like Palley market just needs to know that they're coming to a good conclusion. Even if everyone involved in this specific dispute loses money, we're just going to keep redoing. Like, if you know that you can attack the system and just raise disputes and settle for, half of the amount, that's like a worse system in the end. Does that make sense?
Well, you're saying,
Yeah, please.
You're saying that. Hey, Nick, how you doing? You're saying that it's like paying a filing fee, right? If you have to pay a filing fee and it gets larger each time, then you're not going to do that. I guess, and that's sort of already exists in the real world. The problem is filing fee, litigation costs. In the real world, you can typically only file a lawsuit once, or you can dismiss it without prejudice and refile it again. You can't file it over and over again. And the disincentive in doing that is it costs money. There are serial.
Well, there's like an appeals court.
What's
There's like appeals courts, you could say.
Sure, there are, but take our friend Craig Wright, who litigated, whether or not he was Satoshi in the United States, in England, in Norway, multiple lawsuits. I hear what you're saying. I'm not sure that you need PNK or crypto economics to create the incentive system to prevent vexatious litigation. Again, like what I come back to is, and I think I'm thinking about it differently. I'm fighting the last war. I'm thinking about the system that I built. I'm thinking about using actual games, using technology to resolve disputes, and not using people, not using arbitration or mediation. So
yeah, well, I know for like we had looked into using Kleros for Teller, and part of the benefit of using like the PNK token versus like your own token. So like if we're in the on-chain world, is like having an external system is really beneficial, because you have a lot of these problems that come up, like, you know, like with oracles, like should we slash our oracle, and, you know, like Chainlink, for instance, will just say like, well, we're never wrong. Like it was obvious, you know, like we didn't do anything wrong. It's the system saying we should be slashed. You know, so having a third-party system that's outside of your own system, because like saying your own system was wrong is like, well, you would never do that. So, you know, this is like beneficial in some way.
But that's so different, Nick, than the I built the website correctly and you didn't pay me. What you're talking about is a system or mechanism issue. You're talking about something that is highly, highly technical, almost automatic, and it feels different to me than the customer service issue with whether or not an exchange, you know, properly credited someone's account. So I don't know. I mean, what I like in sort of dispute resolution and mechanism design is taking people out of the loop completely, because I think that it is when you have people involved and you have trust involved, you're suddenly doing the thing that blockchain is supposed to solve for, and you're reintroducing a problem into a system that's already broken. So yeah.
No, it's fair enough. I think, yeah.
I'm not sure it is, but you know, it's what I think.
Well, I think we're still figuring out ways to, you know, this is where, like, I'm sure you guys have talked a little bit about like eigenlayer too, you know, like the inner subjective piece where they say like the only things that we can actually provide services for are things that are like clearly obvious. Like, you know, like basically you can't programmatically say what it is because it's just, there isn't a good data source or way to get it on chain, but it's clearly obvious to everyone who's a human what the answer is. And that's like, it's like solving for that problem is very different than solving for like something that could go either way, you know, depending on your opinion.
Yeah, I think that's right. And that's like when I talked about like trying to find the thread or like seeing like the light underneath the door. That's sort of directionally where I head.
Yep.
Because I do think there's something here, like you're answering a question. And the question to me is at least as important as the answer. And maybe there's something about the direction here too is, this is so trite. I remember like when I was in law school, I graduated in 98. We had this common joke, which was at the end of anything you said, well, now with the internet. And so I'm going to say now with AI, but I think that this is a solution set for autonomous and semi-autonomous systems. And maybe what you end up doing is maybe if you're dealing with autonomous systems in the first instance and they can be wrong, maybe you need to reintroduce a human adjudication layer into autonomous systems to act as a check on those systems, because like they're full of error, right? An LLM, which scrapes the web for information, is full of mistakes because the internet is full of mistakes. So maybe that's maybe that's what it is. I know it's not what you're building. I know it's not the passion here, but you know, it's an idea.
Okay, thank you. So simply another question. There is another question.
Nicholas had another set of questions. There's sort of two sets of questions here, and then after that, I think that's the extent of them, unless anybody else wants to raise their hand to kind of jump in here.
So Nicholas, please, your second question.
I mean, it was kind of just on this, you know, it was a very similar question, just talking about a lot of this stuff, and I think Steven's right in how he talks. Like maybe you can have Kleros as the human element fall back to an LLM or something like that, and
That's fucking interesting.
yeah.
I really thought about that, but that is really interesting, isn't it?
Well, because I think like especially if you do it for things that are more, you know, obvious as far as the answers go, then it could sort of make something happen, I guess you could say. And, kind of like I would say a lot of this goes back to, like Stephen was talking about, more of the problem in the blockchain space, I would say, is just like, we don't specify our contracts necessarily good enough. So like in the Palley market case or something like that, where like, do we need a lawyer like Stephen to just write up our contracts better? And then it turns the Kleros court more into something less subjective about it. And maybe that's it. I don't know. Yeah. Do you have any thoughts?
Okay. So simply, there is another question from someone else.
No, that's all of them, Paolo. So I don't know if you want to move to closing thoughts.
So maybe we can close. There are some of you who wants to make some additional comments. We are going towards the conclusion of this session. So, anyone?
I can just briefly say.
Yeah, please, Alex.
Thank you, Paolo. Thank you, LexDAO. I think it was a very healthy debate with different viewpoint, and we really appreciate that. Yeah, if you are interested into Kleros, I've put some link there on some specific topics. So yeah, mentioned Colin Rule about the former director of online dispute at eBay and PayPal, so you can have a look there. I put also a document about game theory, and I put also a link around like the famous big use case and specific cases about Kleros. So feel free to have a look. You can reach us as well if you have any, if you want to talk about anything, any questions around our system. We will be happy to answer your questions. Thanks.
Anyone? Stephen, Alex, Ines, Facundo, please.
No, thanks. I really enjoyed chatting with you all, and I enjoyed reading all of your stuff. I really did read it. It's an interesting problem set, and it's early days still. So look forward to seeing what you end up with.
Yeah, thank you.
Likewise, thank you very much. It was very interesting.
Yeah, thank you.
Thank you.
Okay, so thank you.
Thank you, everyone.
So thank you everyone for being here. Thank you to our speakers, and as LexDAO, we really thank everyone. I think it was a very interesting and open debate, and this is what we are trying to do here, just to make something interesting. Let me say intellectually interesting. So thank you everyone, and I'm going to close now. Bye bye.
Thank you.
Bye everyone.
Thank you.